Amisha, how are you?
I'm good. How are you, ma'am?
Good. So it is your first attempt?
Yes, ma'am.
Okay, nice. So s- from where you have did your LLB?
Ma'am, Petroleum University, Dehradun,
Okay,
UPS.
nice. Done with LLM as well?
No. I have only done BBA LLB, honors in corporate laws.
Okay, nice. So any particular subject very much appealing to you?
I have studied every subject, but I guess evidence law is seems fine to me.
Evidence?
Evidence law.
Okay. So what do you know about Pakala Narayan Swamy case? Anything particular about that?
Yes, it is a foundational case for the confession, the term confession, which has not been defined under evidence law, but the meaning of the term, the definition has been derived and explained by our honorable judges in that case only for the very first time.
Okay, and what about Agnu Nagesha?
Abhinagesha is somewhere related to the FIR, where the person who killed has himself went to the police station to register the case. So that is about the confession and the FIR thing, the evidentiary value of the FIR, which is in confessory form.
Okay, I'm just giving you one situation. Just answer this question. For example, very good morning. Husband was, going for a job. तो अपने ऑफिस जा रहे थे. तो वाइफ वॉज स्टैंडिंग इन फ्रंट ऑफ द गेट एंड वाइफ सेड कि वो मतलब पूरा प्लानिंग के साथ वो बैठी हैं केरोसिन ऑयल वगैरह लेकर. तो उन्होंने कहा कि मुझे प्लीज़ 5 लाख रुपीज़ दे दीजिए. तो हस्बैंड ने पूछा कि क्यों दे दीजिए 5 लाख रुपीज़. तो शी सेड कि मुझे आज शॉपिंग पे जाना है अपनी फ्रेंड्स के साथ, तो आप मुझे दे दीजिए. तो हस्बैंड ने कहा कि ये तो बहुत अनरीजनेबल सा डिमांड है, 5 लाख इज सो मच, तो मैं तो आपको नहीं दे सकता. तो वाइफ ने कहा कि अगर आपने मुझे 5 लाख रुपया शॉपिंग के लिए नहीं दिए तो ये जो केरोसिन ऑयल है ये मैं अपने ऊपर डाल लूंगी और अपने आप को जला लूंगी. समझे आप? सिचुएशन को समझ रहे हो? ठीक
Yes.
है. तो आप मुझे ये बताइए कि तो हस्बैंड जो है वो पुलिस स्टेशन गए, हस्बैंड ने सारा जो इंसिडेंट है वो पुलिस स्टेशन में ऑफिसर्स के सामने नरेट किया. कोई ऐसा प्रोविजन भारतीय न्याय संहिता का या फिर आप आईपीसी का ही बताएं क्योंकि अभी आपके में ओल्ड लॉज आ रहे हैं. आईपीसी का ऐसा कोई स्पेसिफिक प्रोविजन जो इस इंसिडेंट से अट्रैक्ट होता है, हस्बैंड जो है उसके अंदर जो है वो वाइफ के अगेंस्ट केस फाइल कर सकता है?
Yes, ma'am. So, ma'am, firstly, I would like to
कैन यू
answer
बी अ
this.
लिटिल लाउडर प्लीज?
Yes, ma'am. So, firstly, ma'am, I would like to answer this question by stating that the case would not be covered under abetment. So, the wife could not say that the husband abet the offense. So, that would be the case under the threatening, under the excuse me, ma'am, uh, please allow me a moment.
या श्योर व्हाई नॉट. इट्स वेरी सिंपल.
Yes.
First of all, just I really want to say one thing to all the students, like to all the aspirants who are appearing for the interview. Never give diplomatic answer. If you will give diplomatic answer, na you will keep yourself in trouble. So it's very simple कि अरे हस्बैंड जॉब पे जा रहे हैं, वाइफ जो है वो गेट पे खड़ी हो गई है, कह रही है कि दे दो मुझे
Hmm.
पैसा वरना मैं अपने आप को जला लूंगी. तो
Hmm.
आई विल आंसर क्वेश्चन फॉर यू बिकॉज आई थिंक आप जो है कहीं ना कहीं भूल रही हैं. Forget abetment and everything. It's very simple. It's extortion.
Yes, that is extortion.
Yeah.
Yes.
You are right कि threat है, but आप provision relate कीजिए ना. बहुत simple provision है. Okay.
I was getting on 504, like threatening and like for uh,
Intimidation.
intimidation. Yeah,
No. It's extortion. Okay, sir, you
I
please
was
you can
getting
ask.
there. I was
Yes.
recalling the provision for intimidation.
Over to you, sir.
आपने हॉबीज में लिखा है मेडिटेशन एंड लिसनिंग टू स्पिरिचुअल सॉन्ग्स.
Yes, sir.
ये कहाँ से सीखा आपने मेडिटेशन भाई? तो बड़ी डीप सब्जेक्ट है ये तो, फिलोसफी है. कहाँ से सीखा? हाउ डिड यू डेवलप इंटरेस्ट इन ऑल दिस?
Sir, I am not an expert in meditation, but I have developed a hobby while I was studying and preparing for my judicial services, because it was like very monologue thing. I was studying whole day and my mind was getting all filled up by all the logics and law things. So I was trying to calm my mind. So then I got to know about meditation and I started practicing by watching videos from YouTube. And then I have also enrolled myself in the course from Yog Tattva. So I got the course of 14 days from there. And then I got to know about the basic things about the meditation. Then I got enrolled myself for the guided meditation process. So from that, I started my journey in meditation.
That's very interesting. At such a young age. क्या फायदा लगा आपको उस मेडिटेशन से?
I am now more confident, focused, and I can now control my nerves. Earlier, I used to overthink a lot of things, but now I can control my thinking process, and I'm very patient after I started practicing meditation.
कुछ पढ़ाई लिखाई में कंसंट्रेशन इंप्रूव किया कि नहीं उससे?
Yes, absolutely, sir.
तो बहुत कंसंट्रेशन के साथ कौन सा सब्जेक्ट पढ़ा आपने?
I guess I started solving questions for prelims. I started my focus was increased in the MCQ pattern. I was more determined and I was more focused while I was solving all the MCQs question. And after that, I started learning all the case laws name very easily after I started doing meditation.
ऐसे भी
No,
जाना
no.
ऐसे
What sir is asking is कि which subject, कौन सा सब्जेक्ट आपने बहुत ज्यादा कंसंट्रेशन से पढ़ा है?
वो
सर
क्वेश्चन
ये
ध्यान से
पूछना
सुनिए
चाहते हैं.
प्लीज, क्वेश्चन ध्यान से समझिए कि सर क्या पूछ रहे हैं.
Sir, evidence law.
why only evidence law?
Because I guess that is a subject which excites me more, since it is related to all the procedure which is followed in civil as well as criminal cases.
अच्छा, ये नार्को टेस्ट जो होता है, इसकी
Yes.
फाइंडिंग्स जो है, ये एविडेंस क्यों नहीं ट्रीट की जाती है फिर?
Because that is not firstly I would like to say is that is not voluntarily and that is not 100% accurate, so we could not rely on that very easily, although there are many judgments in which that issue was arise, like
जैसे अगर मान लीजिए नार्को टेस्ट में कोई चीज रिवील होती है और वो और एविडेंस से corroborate होती है ना?
yes.
तो अ फाइंडिंग कैन पॉसिबली बी अराइव्ड एट. तो इस अगर उसको शामिल कर लिया जाए एविडेंस एक्ट में, तो उससे नुकसान क्या है? सब्जेक्ट टू corroboration by some credible evidence, other credible evidence.
So that is not
मान
voluntarily.
लीजिए स्टैब करके किसी का मर्डर किया, नार्को टेस्ट में एक्यूज बताता है कि साहब वो चाकू वहां रखा है, मैंने छिपाया है. फिर उसको बाद में जब फुली कॉन्शियस, तो उसको लेके जाते हैं और चाकू वहां से रिकवर होता है. तो ये नार्को टेस्ट का जो एक उसका रेवलेशन था, कैन इट नॉट हेल्प?
Absolutely, sir, it could help, but our system thinks that it is not right to convict any person on the basis of the statement which he has not given voluntarily. Also, sir, our law system is based on the term that every person has a right to defend himself and every person is presumed to be innocent. So we could
अगर
not.
आपका ये प्रिंसिपल मान लिया जाए, तो जैसे पुलिस के सामने कन्फेशन इनएडमिसिबल है, ऐसे और एजेंसीज के सामने कहीं कहीं कुछ लॉज ने एडमिसिबल भी किया है. जैसे कस्टम्स एंड एक्साइज डिपार्टमेंट के सामने अगर कन्फेशनल स्टेटमेंट है, इट इज एडमिसिबल इन एविडेंस. तो वो भी तो उनकी कस्टडी में रह के दिया है, वहां भी मारपीट की गुंजाइश है, थर्ड डिग्री टॉर्चर की गुंजाइश है. देन व्हाई इज दैट बीन मेड एडमिसिबल? बिकॉज इन दैट केस आल्सो इट इज नॉट वॉलंटरी.
Absolutely, sir. Sir, the reason which has given by our honorable court that the custom officers are different from the police officers in the form of the investigating power. So officers have the power also to sentence them or to order for any punishment and the fine thing, which police officers do not have. So our system is still bound by the term that confession given in front of the police officer is not admissible because there are chances of the high torture and involuntary confession. Whereas in the recent cases, the court has allowed the validity of the confession given in front of the custom officers in case of custom and goods act.
Mhm. Very good. The meditation appears to have actually helped you in understanding a subject.
Yeah.
Continue with it.
Thank
Anything
you.
you would like to ask, ma'am?
Yeah, sure, sir. Like, suppose a witness says in front of police कि अपराध हुआ है 2 बजे. And when he is examined at the stage of trial, he says, no, 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 no. अपराध 2 बजे नहीं हुआ, रात में 8 बजे हुआ है. So how you'll contradict that witness?
Yes, ma'am. Ma'am, firstly, the value of the information given to the police officer is not very highly relevant. That is only used for corroboration and contradiction as per Section 162 of CRPC. So, if the person changes a statement in the court, so the court will take and examine all the available other evidences and try to rely on the statement which is more relevant. And other than that statement, the court will also examine the court will also examine the other evidences which are present in front of it and other witnesses as well.
ओके सो आईओ साहब कहेंगे कि अरे आपने तो हमारे सामने कहा था कि 2 बजे अपराध हुआ है, अब आप यहाँ पे अपनी बात से मुकर रहे हैं. तो जब हम उसको कॉन्ट्रडिक्ट करेंगे तो उस विटनेस की एविडेंशियरी वैल्यू क्या होगी? नो डाउट अबाउट द फैक्ट दैट विल कंसिडर द अदर थिंग्स आल्सो,
Yes.
but as you answered, but what will be the evidentiary value of that particular witness in that case?
Yes, ma'am. So, ma'am, the evidence given by that witness will not be absolutely retarded, but the evidentiary value of that witness will only be in corroboration to that extent only. There is a one term called retracted confession. So that is a thing where the confession is not absolutely retarded or rejected, but it is to be seen that it could be used as a corroboration in other terms.
Okay, can we say that the testimony will be weak?
Yes, ma'am, absolutely.
Okay.
That would be weaker kind of evidence.
Yeah, it will be weaker kind. Of course, पहले कुछ
Yes.
कह रहे हैं, बाद में कुछ कह रहे हैं, तो judge will be like कि they're not
Yes.
staying on the point, right? Okay, so what is the evidentiary value of WhatsApp? Like WhatsApp में we often chat, right? Business transactions को लेकर, anything we chat on WhatsApp. तो WhatsApp की evidentiary value क्या होती है और आप कैसे WhatsApp के chats को कोर्ट में prove कर सकते हो?
Ma'am,
How you will prove that?
yes, ma'am. Ma'am, that comes under the documentary evidence as per the latest amendment of Bharatiya Nyaya Samhita as well. The legislature has taken an initiative where it has included all the electronic evidences earlier in evidence law and earlier in IPC as well. So there was a lot of conflict where the electronic evidence was not per se admissible. So there were a lot of introduction in amendments and by the judgments like R.M. Malkhani case. Now the legislature has taken the initiative to recollect all the conflicts and to recollect the electronic evidence. So WhatsApp chat would come under the electronic evidence and it can be proved by showing the WhatsApp, giving to the WhatsApp access, since the WhatsApp has also given that it is a protected chat like one-to-one. So it could be relevantly proven by showing the WhatsApp chats under the electronic evidence.
सेक्शन 65B क्या कहता है?
Sir, Section 65B. Yes, sir. Section 65 of Evidence Act shows how the electronic evidence would be proven. There are two kinds of evidence documents: primary and secondary evidence. So, by the introduction of the amendment in 2000, legislature has introduced Section 65A and 65B. Section 65A is the introductory and the section which allows that electronic evidence could be given. Section 65 gives a procedure for giving the electronic evidence in court, like by proper showing the certificates, by authentication of the examiner.
और कुछ
तो
इसके अलावा भी?
हाँ,
Yes,
please.
sir. Yes, sir. Section 65B also states that the computer from which it has been given must be in regular course of business, must be properly working, must be used in ordinary course of business, and must not be tampered. So these are few conditions and essentials which are stated in Section 65B of the Indian Evidence Act.
Can you say something on proper custody? The electronic evidence has to be produced from a proper custody. What do you mean by that? What do you understand from this term proper custody?
Yes, ma'am. So, ma'am, it is there. There is one provision. If I support my answer by the provision of Evidence Act, so there is a provision of 90A in Evidence Act where it is shown that if the electronic evidence is produced from the proper custody, then it may be presumed that it is genuine. So the time period given is 5 years. So the word proper custody means the person who has the actual and the real authorization over the resource, the person in whose custody it must be legally there. So that would be the proper custody of the electronic record.
Okay. So as we know that new criminal laws implement हो चुके हैं. So
Yes,
what
ma'am.
is the reason behind bringing these new laws? What do you think? What are the reasons?
Ma'am, foremost reason I would like to state here is like it is the high time to bring the change in the colonial in the law which is prevalent from the colonial time period. Earlier we used to call it Indian Penal Code, Evidence Act, but now the legislature has taken the initiative to recognize it as Hindustani, where it is called Bharatiya Nyaya Sanhita, Bharatiya Sakshi Adhiniyam, giving it proper Hindi meaning. Second, earlier there was a lot of like the law was too much old that it needs to be changed and it needs to be recognized as per the society where there is a need of a high amendments. Like in Bharatiya Nyaya Sanhita, there is a introduction of crimes, new crimes like organized terrorists, and changes in the punishment, like the transportation of life is has been too old. Also in the Bharatiya Sakshi Adhiniyam, there is an introduction of the technology development, since our society is highly dependent on the technology nowadays, so it is highly required to bring that changes.
Okay. One last question. Constitution, constitutionalism, and constitutionality make a difference. How you will define all
Constitution.
these?
Yes, ma'am.
Difference.
Constitution is the document, constitutionalism is a soul, constitutionality is a system which we follow.
Okay. Okay. Sir, ma'am, please.
एक चीज बताइए, जैसे आपसे पूछा गया अभी थोड़ी देर पहले, एक आदमी है उसने अपनी टेस्टिमनी में टाइम ऑफ अकरेंस चेंज कर दिया है ना? तो कोर्ट्स ने कई सारी केस लॉज में ये भी कहा है कि साहब जो ट्यूटर्ड विटनेस है उसका अकाउंट अगर थोड़ा अरसे बाद भी लिया जाए तो इट विल बी लिटरली रिप्रोडक्शन ऑफ द अर्लियर स्टेटमेंट.
Yes.
एक चीज होती है कि भाई नेचुरल मेमोरी लॉस
Yes.
है ना, जैसे मान लीजिए कोई सीन ऑफ अकरेंस से आप जा रही हैं, कोई तेजी से मोटर बाइक आई, उसने किसी बच्चे को टक्कर मारी, बच्चा जोर से गिरा और मोटरसाइकिल वाला भाग गया, तो इट इज आपका अटेंशन जो है वो इट विल बी मोर ऑन द बाइक राइडर्स रैश बिहेवियर, द इंजरीज टू द चाइल्ड वगैरह वगैरह. उसमें आपसे पूछा जाए कि साहब उस मोटरसाइकिल का रजिस्ट्रेशन नंबर क्या था, there is always a chance that you may miss it
Yes.
because your attention has been diverted to something which in your opinion is far more significance.
Yes.
तो ऐसे केसेस में क्या फैक्टर्स होते हैं कि आप विटनेस को बिलीव करें या डिसबिलीव करें या पार्टली बिलीव करें, कोरोबोरेशन रिक्वायर करें? कुछ थोड़ा सा इस पे प्रकाश डाल पाएंगे आप?
Yes, sir. Yes, sir. So, according to me, if such kind of situation arises, then rather than relying wholly on one statement, like what is the time of the crime, we could have examined like other evidence, or if the person is dead, we can have the post-mortem
आपने यहाँ
report.
पे इससे फर्स्ट क्वेश्चन एज अ जज, सी जब एविडेंस चल रही होती है तो जज हैज टू बी प्रोएक्टिव. आपने ये ना सोचा ना इनसे पूछा कि साहब आईओ ने जब स्टेटमेंट रिकॉर्ड किया था उसमें और एक्चुअल कोर्ट में जब टेस्टिमनी उसने दी उसमें कितना टाइम पीरियड बीता था. हो सकता है 5 साल बाद हुआ, इन्वेस्टिगेशन लंबा चलाओ, ट्रायल पेंडिंग रह गया, और 5 साल बाद उसका मेमोरी लॉस हुआ और उसने टाइम थोड़ा सा चेंज कर दिया, आपने स्ट्रेट अवे कह दिया कि हम उस विटनेस को डिसबिलीव कर देंगे। What is this the right approach for a judge?
No, sir. No, sir. Sir, we could not disbelieve the witness outrightly, but we could examine the other factors, like what would be the state of the mind of the witness at the time of giving the statement to the IO, and what is the state of the mind, and what are the other personal effects on the witness at the time he is present in the court, and what are the other circumstances or situations from which he is going through. Since I believe if the person is personally inferred in that crime, so his state of mind could be different and he could not analyze the situation outrightly. So that is not right to disbelieve all the statement made by the witness at that moment, but we could examine the other factors and circumstances with the presence of the other evidence at that moment as well.
इसीलिए जज को प्रोएक्टिव रोल एक्सपेक्टेड है जज से।
Yes.
दो इंडिविजुअल्स की मेमोरी कैन नॉट बी अलाइक, किसी की
Yes.
लॉन्ग टर्म मेमोरी अच्छी हो सकती है, किसी की खराब हो सकती है। तो अगर उसी वक्त आप उससे 4 सवाल पूछे टू टेस्ट दैट इंडिविजुअल्स मेमोरी एंड हिज पावर ऑफ ऑब्जर्वेशन, द स्किल टू ऑब्जर्व, तो ये चीजें जो वो आंसर कर रहा है उसमें जो वेरिएशन आ रहा है वो नेचुरल वेरिएशन है या अकरेंस के टाइम पे वो प्रेजेंट ही नहीं था, इस कंक्लूजन में पहुंचा जा सकता है। इस पे आप बेहतर डिसाइफर कर पाएंगे, है ना? तो
Yes.
your answer I think would have been slightly more mature and thoughtful अगर आपने ये सब चीजें भी कंसिडर की होती।
Yes, sir. Yes, sir.
Try to understand what I'm saying.
Yes, sir.
इसीलिए
Absolutely, sir.
आपके इंटरव्यूअर्स है वो ये जज कर रहे हैं आपको अल्टीमेटली उन्हें क्या देना है। अगर आपको पास करेंगे तो यू विल बी असाइन्ड द रोल ऑफ अ जज। हाउ सूटेबल आर यू फॉर दैट रोल? यहाँ पे तो यही जज करने के लिए हम लोग बैठे हैं।
Yes, yes.
तो इसलिए थोड़ा सा इस बारे में सोचिए और जल्दबाजी मत करिए। यू आर इन अ हेस्ट टू आंसर, और वो आंसर्स जो आप दे रही है वो जो आपको लिटरली याद है, आपकी अपनी एनालिसिस इसमें नहीं आ रही है। समझ रही हैं आप?
Yes.
Meant to discourage you by any standards. This is just a tip which you if
Yes, yes, absolutely, sir.
अपनी सोच में इनकलकेट करेंगी तो आपके आंसर्स जो है वो फॉर अ जज दे विल बी बेटर आंसर्स for the interview board. They'll be more impressed. This is my
Yes, sir.
thank you very
Thank you, sir. Yes, sir.
So my feedback will be, my dear, you need to be more clear. Think before you say, and wish you all the best.
Thank you, ma'am.
Thank you.
All the best, Amisha.
quite well considering your age and experience. You answered very well. Thank you.
Thank you so much, sir. Thank you.